distinguished guests, teachers, staff members, and the student of Batch 29. I welcome you all to the final day of Deeksharambh and present to you the fifth speaker of the day, Dr. Shehwal Satyarthi, sir, an Associate Professor of Law at the Faculty of Law, University of Delhi. I kindly request Dr. Pooja Jaiswal ma'am to present a sapling to sir as a token of gratitude. Sir has widely attended up teen of national as well as international seminars along with various workshops, conferences and symposiums as a resource person. He has to his credit many publications in reputed journals. His areas of interest are IPR, TRIPs, WTO, social justice and traditional knowledge of family law as well as other areas of subject. I invite sir to address us on the concept of rights and challenges of intellectual property. So,
Very good afternoon to all of you. So you all have joined 5 years integrated law course. Just few days back, I hope so, or a month back, days. So you all a very new entrant in the field of law. The topic which I am going to deliberate is of great importance, though it will be taught to you in higher semesters, intellectual property rights law. But being a law student, you must have some fundamental understanding, the basic knowledge of almost every branch of law, so that you can connect yourself with the issues having interlinking interrelationship. So don't think that when you are in first semester, you are to learn only these subjects. When you are in second semester, you are to learn only these subjects. And you are least concerned about the subjects which are to be taught in higher semesters. And you become ignorant about those subjects. So my first advice to all of you, that you should not develop this kind of habit in you. Try to have a basic knowledge, understanding of each and every area of law, even being a student of first semester. Then only you will be able to connect yourself. Then only you will be able to appreciate the problems which you may get relating to other areas of law. That's why here I am going to discuss with you certain fundamental aspects of a very interesting and emerging branch of law, that is intellectual property rights law. What we do here, it's a kind of property, but it's not ordinary kind of property. Why? Because we cannot see this property. This property is not tangible property. This property is not corporeal property. There is no corpus of this property. Rest of the properties you can see, you can perceive through senses, you can touch. They are tangible properties. They are corporeal properties. But here this kind of property is incorporeal property, intangible property. Moreover, here we talk about right as a property. And that's very interesting part of it. Right as a property. In early times, there was no concept of right as a property. People used to consider only physical assets as property. A physical thing having some value in the eyes of law considered to be property. But subsequently, when people started realizing the value of certain rights, importance of certain rights, then only they thought over this kind of aspect, that why not to consider right as a property. So this intellectual property right is one of those things where we consider some incorporeal right, some intangible thing that is right, that cannot be seen. We have started considering it as property, right as a property. You may be getting some information about different kind of properties, movable, immovable, tangible, intangible. You might have studied even during the preparation of your law entrance examination. But when we talk about the jurisprudential aspect behind it, there is one categorization, jura in re aliena, jura in re propria. Jura means right, legal right. When you have some legal right in your own property, jura in re propria. You own some property and you have certain rights in relation to that property. Suppose you all in possession of a mobile phone, that's your property. So you have several rights in relation to that one property, mobile phone, including right of destruction. If you want to destroy that mobile phone, can anybody stop you legally? Can anybody prevent you legally? No, not at all. So you hold several rights in relation to that one mobile phone. You hold several rights in relation to whatever property you have. So that is jura in re propria. So I have certain properties, physical properties, and I hold certain rights in relation to that property. Fine. But there is one more categorization that's very interesting. Here, it's not your property, even though you hold certain rights. So where you hold certain rights in relation to someone else's property, aliena, legal right but not in your own property, legal right in someone else's property. And there are so many legal concepts highlighting this category, jura in re aliena. I can give an example. Then you would realize, oh, yes, this is right. I have certain right, but not in my own property, in someone else's property. Suppose you are a shopkeeper and someone has given watch to repair. And that person wants that watch after repair without paying the cost of repair. Being a shopkeeper, what do you think? Do you have any right? Tell me. You are a shopkeeper and you have repaired that watch, and that person wants to get back that watch without paying the cost of repair, claiming that I am owner of this watch, I am lawful owner of this watch. Can that person compel you to return the watch without paying cost of repair? You tell me. No, not at all. Here you hold certain rights in relation to someone else's property. So this is jura in re aliena. You might have heard about mortgage. Have you heard about mortgage? It's about borrowing of loan. When you are to borrow loan, definitely that person who has lended money wants some security. And where you give security, and that security in the form of immovable property, that is mortgage. So whatever rights a mortgagee has, I'm not talking about rights of a mortgager, the rights of mortgagee. So whatever rights of mortgagee are concerned, what kind of rights they are? It's not his property. He has got this property as a security. The person who wanted to get some loan, a debt, as security, that person gave you this immovable property. And in that immovable property, you hold certain rights. So what kind of property it is? What kind of right you hold in relation to that property? That's important. So property is definitely immovable property. But the right which you hold in the property which is not of yours, this property is of someone else's. So jura in re aliena. Under this kind of categorization, what is significant? Whenever we talk about these categorizations, jura in re aliena, jura in re propria, corporeal incorporeal, tangible intangible, when we started having or getting these kind of categorizations, when we started realizing the importance of value of a right as a property, because right is the thing which cannot be seen. Otherwise, rest of the properties can be seen, can be touched, can be perceived. We started thinking about intangible. What comes under that intangible? Tell me. What comes under that incorporeal? A property not having the corpus. We are talking about which kind of property? Having no corpus, no body. Corpus, no body, no shape. Definitely a right. So that's why this intellectual property right is a property. Here we talk about right as a property. And nowadays it has acquired great importance. I can tell you that earlier trend was at the time of merger and amalgamation of the companies, when two companies they decide to merge, or a company, a big company wants to take over another company. Definitely they negotiate. As far as assets are concerned, they negotiate, then they value, then they take a decision whether to take over this company or not, whether to take over this particular firm or not. So all these processes, they used to negotiate on physical assets. But nowadays, they have started negotiating first on intellectual property. First question they ask, how many patents your company has? Why they ask how many patents your company has? Because the value of a patent is more than value of physical asset. So where value of a right is more than value of a physical asset, so definitely that's most important thing to be discussed. And that's why they start this discussion, they start this negotiation on this aspect only, intellectual property right. How many intellectual property rights you have? Because with the help of one intellectual property right, they can make many billions. Large number of physical assets can be created with the help of one intellectual property right, I can tell you. Recently, we all witnessed this pandemic, COVID-19. And large number of companies, scientific institutions, universities, they were engaged in what? Inventing a vaccine, invention of a vaccine. Just imagine, only one company could have invented this vaccine. Only one company. And just imagine the situation. What kind of monopoly that company would have in the market, and how much wealth they could have created with the help of that one single invention, having intellectual property right in relation to that invention, meaning thereby having exclusivity. Whenever we talk about this intellectual property right, it confers several rights. It gives you exclusivity. Only you are entitled to exercise that right. Nobody else is entitled to exercise that right. If anybody is to exercise that right, that person will have to obtain a license from you. Meaning thereby will have to obtain your permission. Without your permission, nobody can exercise that right. This is importance of this intellectual property right. And furthermore, in today's world, you all know this is globalized world. We are in the era of WTO. The situation was so different before 1995. But after 1995, we all have witnessed the change in global economy. What kind of economy we have, what kind of society we have in terms of economy, finance. We have removed all the barriers. Otherwise, there were so many barriers, trade barriers were there before WTO. But after WTO, we removed large number of barriers. And nowadays, we are in the era of globalization. And that's why we talk about free trade. Free trade in this globalized world. That's why we started realizing the importance of this intellectual property right. Because of emergence of different kind of challenges, threats in that era of globalization. Suppose you are to show your talent in a confined room. Hardly 10-20 people are there. So you have this apprehension in your mind that if I show this talent, they all would come to know about this talent, they would learn this talent, and they may use this talent at some other place in their own name, that I am so talented, I know this, I have this knowledge, I have this information. So you are less fearful. But suppose you are to show that talent among large number of people. Now you are so careful. You become reluctant. Why do you become reluctant? Because if I share this knowledge, this information with large number of people, then I would lose my importance someday. Because when everybody knows about it, everybody can make it, everybody can exercise this kind of right. Are you getting my point? Then who will ask me? What would be the value of my talent? Because everybody knows about it. That's why what they want exclusivity. Only I should exercise it. Only I have this right to exercise. If others are to exercise, they must ask me, they must obtain a permission, they must obtain a license from me. Then only they should exercise this kind of right. So, whenever we talk about this intellectual property right, one basic thing that I want to share with you, that there is no one single right in the name of intellectual property right. This is first clarification I want to give. If you think that there is any right in the name of intellectual property right, then you are mistaken. There is no right in the name of intellectual property right. There are several rights, and as because of the nature of those rights, we put them in this single category, this bracket. And what this bracket is? Intellectual property right. Normally people say that a right which is created through human brain, a right which is created through human intellect is intellectual property right. To some extent, it's correct. But considering the scientific advancement, technological advancement, now this is not so correct. Now even machines are able to create property with the help of their own intelligence, and that you call artificial intelligence. Artificial, this is era of artificial intelligence. So things are changing so quickly. Earlier, we used to talk about only the creation, innovation with the help of human brain. But now, you have to write one article, so you have to spend time, read, then writing, improving, typing, so many activities are there. But with the help of artificial intelligence, within fraction of second, you have to write one essay on any topic, and you just give a command and you ask that chat GPT, and your essay will be prepared in fraction of seconds, within minutes. So this is AI, artificial intelligence. So challenges are still there. But whenever we talk about the development of any branch of law, whether it's intellectual property right law or any kind of law, what is important there? That it must be dynamic. Being a law student, we always believe in dynamism. If you are not believing in that dynamism, then definitely you will be getting absurd results, absurd outcomes. Why? Because law is something which must not be a static. Law should change, and that law should change as per the needs and requirement of the society. You just imagine 30-40 years back, whether we were thinking about same-sex marriage. Was there any need and requirement of any law relating to same-sex marriage? No, not at all. But today we are thinking about it. Just imagine 50 years back, 100 years back, whether there was any requirement of any need of a law relating to nuclear science or nuclear energy or a space technology. No, not at all. But we started thinking about it. Why? Because of this one fact that law must be dynamic. Dynamism should be there. It must not be a static. Same is the case with intellectual property right. So it's still in developing process. If we think that we have developed a kind of law even after WTO, when we became signatory to that TRIPS agreement and we reformed our existing laws, we repealed so many existing laws, we brought new laws, we amended our existing laws, so many activities were actually happened after 1995, after that WTO. But still we are in that phase of development in this area. Why? Because of the impact of science and technology on this branch of law. Science and technology, they play very pivotal role in development of this kind of law. And here we always see a kind of race between law and science and technology. You all know that there is science and technology. Every day you see a change, a development in the field of science and technology. Whatever technology was in existence yesterday, that same technology is not in existence today. It will become obsolete tomorrow. It happens or not? You tell me. You all young people, techno savvy, you all use mobile phone. How many versions of Android you have used in last 3-4 years? Just tell me. Or iOS, iPhone. How many versions? When you use any software, after quick interval, you get a notification, your update is ready, install. What it signifies? Some update is there in relation to that software. So every time you see a change, you see a development in the field of technology. So being a student of law, if you are not having that kind of foreseeability, how can you make one effective law? Suppose you have made a law in relation to that technology, considering the present challenges. But there is rapid change, rapid development, rapid growth in the field of technology. So whether that law will be effective considering the upcoming technology or upcoming updates in relation to that technology, that's the challenge before people in the field of law. That's why you must have that kind of foreseeability. Having that kind of foresight and having understanding of that technology, that oh, today we have this kind of technology, it's affecting our life in this way. So what will happen if there will be a change in the same technology like this? Earlier we used to watch that science fiction movies, Hollywood movies. But nowadays, whatever you used to call science fiction some 20 years back, today they all have become reality. They all have become reality. So you must have that kind of foresight. Then only we will be able to make one effective law to deal with any legal issue. And same is the case with intellectual property right. So as I said, this is not one right. There are several rights. There are so many other areas, and they all come within this one bracket of intellectual property. And one very interesting thing that I want to share with you, that basically you know about patent, you know about copyright, you know about trademark, geographical indication, semiconductor, integrated circuit layout designs, farmers' right, so many kind of intellectual property rights. Broadly, we categorize them in two categories: industrial property and copyright. Even if you look at that international arrangement, certain international instruments are there, Bern Convention, Paris Convention. Paris Convention came into being 1883. After 3 years, Bern Convention. Paris Convention was for industrial properties. Bern Convention was for copyright. Though this term was not there, that was for literary work. So earlier only literary work was part of that copyright. Subsequently, we added more things into that category. Copyright, like artistic work, dramatic work, cinematograph film, sound recording, computer program as well. So computer program is part of your literary work. So we used to talk about these kind of things centuries back, and still we are thinking about the development and growth in that very area, industrial property and copyright. Why do we have this one category, copyright, separately? Rest of the intellectual property rights, they all come within the purview of industrial property. But we always talk about copyright in separation. Why? Because copyright is the IP, intellectual property, which is most frequently used IP. Most frequently used IP, I am saying. Every time you come across this kind of intellectual property. Right now I am delivering a lecture, intellectual property. This is my lecture. I have exercised my right of fixation, and that's why I have copyright in my lecture. So if you are to record my lecture, means you are to fix my lecture, you have to ask, you have to obtain a license. Because I have already prefixed my lecture and I am delivering it before you. So everywhere, if you are reducing something in writing, copyright is involved. You are doing some creative work, painting, you are taking, someone is taking photograph. Everywhere. So frequently used intellectual property right. And that's why we have kept it separately, because we have offered so many flexibilities in relation to this intellectual property right. We have not offered this kind of flexibility to any other IP. As far as other IPs are concerned, like patent, trademark, designs, GI, or any other kind of IP, a rigorous process is there. Then only you get this reward. But as far as copyright is concerned, you get it automatically. Automatic protection is there. Without formality, without registration, you have created, you are able to get protection from law. But same is the not case with other IPs. As far as other IPs are concerned, you have to undergo a process. You have to prove, you have to establish before the authorities, and then only you will be granted some exclusivity in terms of those intellectual property rights, whether patent or trademark or design. So that kind of advantage is not with the industrial property. That industrial property is also intellectual property. But this copyright, a kind of intellectual property, you get lot of benefit, lot of advantage, lot of flexibility. Why? Because of its extensive use. I mean to say extensive use means most frequently used IP everywhere. So if you are to get permission, or if you are to get some kind of exclusivity from the authorities, from sovereign, from the state, each and every time, and you are the creator, a creative person. So when you indulge yourself in obtaining that permission all the times, when will you create? And society expects more and more creativity from you. Suppose you have watched one good movie and you like that movie. You like that actor, you like the director, you like the story of that movie. So what is your expectation, being audience? That you want more movies from that actor, you want more movies from that director, more and more. I have just shared this example, but what I mean to convey here, I mean to convey that in relation to copyright, it is to do with creativity. And industrial property, they are to do with innovation. And it is said, more and more innovation, more and more good to the nation. Being a nation, being a country, what you want? More and more innovation, new kind of technology. Then only you can make improvement in the field of economy or in any other area. If you are to do something good in agriculture, if you are to do something good in education, if you are to do something good in infrastructure, the basic infrastructure, the road, safety, etc., what you want? And you rely mostly on what? Technology. Have you witnessed constructing a road? What kind of practice we had 20 years back? And we used to construct the very length of the road in a day with the help of that old technology. Few meters, but now many kilometers in some hours. How? With the help of technology. Less involvement of human resource, more use of technology. So everywhere we are in need of technology. And science and technology, they have great influence, great impact on development of any country's economy. That's why even our government, they have started focusing more on IPs. That's why they have given more flexibilities. Earlier, getting patent was so expensive. Process was so rigorous. But now they have liberalized. Now it's less expensive and it's less rigorous. Why? Because they wanted to motivate people that you know about your right, you know about value of your right, and you come and you get patent of your valuable invention. You use it, you exploit it, and with the help of that use and exploitation, the whole nation will be benefited. So that's why if you see the data, what was the grant of number of grants of patent 5 years back and number of grants of patent today, you will see a big change. Big change. Why it has happened? Because even your government wants that you innovate more and more. And when you innovate more and more, you use it, you exploit it, and not within the territory of India, you exploit it globally. Then only we will be able to make more money with the help of that invention. Otherwise, what was the practice earlier? We used to discard someone's innovation in the name of, have you heard about jugaad technology? Jugaad. Have you heard this word jugaad? It's a kind of mockery that you make of someone. Oh, see this jugaad. But that's the technology a person has invented. And if you promote that person, if you give resources to that person, if you help, if you encourage, if you motivate that person, he will be able to make many important improvements in that technology which he has evolved or invented. But what we do, see, this is jugaad, Indian jugaad technology. But no, we are to appreciate, we are to make that person aware about the value of a right involved in that jugaad which he has created. He can make more money with the help of that jugaad. That jugaad is not simply a kind of activity he has done in one small village or in one small area. With the help of that technology, he can make huge money, and that will strengthen the economy of your country. If you market that technology in so many countries worldwide, so definitely he will be able to make more money. So there are so many aspects of this intellectual property, right? And mostly people think that this is to protect the individual's interest because it confers exclusive right. Only you are to exercise this right. When others are to exercise, they are to obtain permission. But this is not a correct proposition. This is not, it seems that it is to protect individual interest. But the ulterior motive, the ulterior benefit is what? Interest of society. Protection of the interest of nation. We want more and more innovation. A society wants more and more creativity. More and more creativity, more and more good to the society. And that's why this is a kind of reward given to that person, that you get this exclusivity. That's why for every intellectual property right, a term is fixed. What is the relevance of that term? A patent is granted for 20 years. A trademark is given initially for 10 years, then renewal. A copyright is given for life plus 60 years. Everywhere term is there. In relation to certain copyrights, 25 years. Everywhere term is there. Why that term is there? Because ultimately that work, that creativity, that innovation shall fall into the public domain. And who will be benefited out of that creativity? Who will be benefited out of that creation? That society, that nation. So, my point here is that whenever we talk about this intellectual property right, we always see a kind of clash between private interest and public interest. And the whole endeavor of this branch of law is to make a balance between that private interest and public interest. It's quid pro quo. It will be taught to you in your paper law of contract. Quid pro quo, something for something. Means you have contributed something. It's all about knowledge. It's all about information. Every IP is about knowledge, information. As you have contributed a valuable information, valuable knowledge to the society, in return of it, in lieu of it, you have got that exclusivity. And you have got that exclusivity under regulation of law from the sovereign. So it's all about quid pro quo. So whenever you study this branch of law, intellectual property right law, you always need to think in this perspective that it is to make a balance between private interest and public interest. Because where you fail to make this balance, then that society won't progress, because we want more and more creativity. That's why it's your responsibility to offer protection. If you are not offering protection to that creator, to that innovator, he would become reluctant. He would become reluctant means he is having a creator or innovator having a good brain. If he would become reluctant, there would be less outcome from his brain. So less outcome from his brain, it would be a kind of loss to the nation, it would be a kind of loss to the society. So that's why whenever you are to interpret any law relating to intellectual property right, you have to think in this perspective, how can we make a balance? Protecting individual interest as well as protecting the interest of nation, the interest of society. So with this note, I am concluding my deliberation. Thank you so much for being a wonderful audience. Thank you so much.
I would like to thank Dr. Shehwal Satyarthi sir, Associate Professor of Law, Faculty of Law, University of Delhi, for addressing us upon the critical aspects of intellectual property and relevant inputs related to the concept, rights, and challenges associated with it. Now, I would like to request Dr. Pooja Jaiswal ma'am, the Assistant Professor, Associate Professor of Law, to present a token of gratitude to the Honorable Speaker. On behalf of the entire family of Dr. Bhimrao Ambedkar National Law University, I would like to extend the heartfelt gratitude to Dr. Shehwal Satyarthi sir for taking the time out to address all of us here today. Thank you, sir.